Welcome back. Coming up next on Question Time, get the updates on the recovery of stolen funds. Our guest has been Nigeria's Justice Minister and the Attorney General of the Federation, Abubakar Malami.
When you look at the whole picture, when you take a holistic view on the corruption war in Nigeria, the political elements seem inevitable in the sense that when people who have access to these funds are being able to influence the political fortunes of their states or even countries. So that brings out the need to really curb this. And there have been several strategy sessions that the federal government has initiated. And recently we have the creation of the anti-corruption committee strategy. How is that helping in fighting corruption in the country?
Anti-corruption strategy is intended to put in place a roadmap, a uniform roadmap that will, at the end of the day, see to the uniformity of operations. For example,
isn't this coming a little or even far behind schedule, coming up with a roadmap at this point of our national life or in this tenure?
Well, you see, I do not look at it from that perspective because the war against corruption is something that is supposed to evolve arising from the dynamics of the operation of the war. There are new tendencies that comes in the course of the prosecution of the war. There are new strategies that comes to mind. There are new factors, there are new components arising from our international collaboration and engagement.
On a matter of principle now, you've because it's important we set the record straight and put things into proper perspective. You talked about the autonomy of the financial intelligence units. There was a point the National Assembly was advocating that it should be domiciled in the CBN.
It's a matter of law. The law that was passed by the National Assembly, which makes the Egmont Group happy and allow for the admission of Nigeria back into the Egmont Group, was indeed had indeed enshrined that out of desire for autonomy, out of the desire for independence, and then perhaps severing the umbilical cord that had at a foreign constitute a source of concern, the agreement now is that it should be domiciled in the central bank, and it has indeed, the law has indeed been passed, and the processes of domiciliation of the unit in the central bank is ongoing.
Let's take a performance audit on this administration's respect for the rule of law. We've seen instances where court rulings are not being obeyed. We've seen instances now, to be specific, the case of El Zakzaki that has been held continuous incarceration in government, which is clearly a violation of the rules. And also, we've also seen the case of the former National Security Advisor, despite the fact that the court had judged that it should be released, and even the ECOWAS court had given the same judgment. And why is federal government still holding on to these people?
Well, if you are now talking of the Court of Appeal, for example, compliance, your judgment as to compliance or otherwise, when you talk of the High Court or Federal High Court, for example, depends on a lot of factors. You cannot adjudge an aggrieved person or aggrieved party that has gone on appeal against a judgment or order. You cannot adjudge him to be in disobedience of the court order when he has a pending appeal, which perhaps has been supported by an application for stay of execution, or perhaps when you have an aggrieved party that filed an application for setting before the court that granted the order for bail, for setting aside the order for bail or variation of the terms of the order.
And if you are not a lawyer, but
yes,
the public are listening
that
to
is
you
why
now,
a lawyer is...
people are now getting mesmerized by your display of technicalities.
Yes, that is why a lawyer is giving you technicalities of the law, because you are not one.
Yeah. Are you suggesting you can't use your influence as the Attorney General to call for the expeditious trial of this case?
No influence has been accorded the office of the Attorney General within the context of the independence of the arms of government particularly the judiciary. So it is exclusively the function of the judiciary in respect of which it exercises exclusive right to determine the phase of trials.
Don't you think there's a bit of double standard here? Because I recall that you played a prominent role in calling on the federal government to quash the case of the Malabo oil deal. And one would expect that similar gesture should be extended by your office to expedite action in the case of this long incarceration of these high-profile cases.
Well, I think there is a serious, or perhaps maybe deliberate, calculated misperception of the office of the Attorney General as far as the Malabu's case is concerned. This is a case that was initiated by an agency of the government, and then arriving from the constitutional role of the Office of the Attorney General, the case was called upon for the purpose of review. Again, the background of the sensitivity of the case, taking into consideration its effects on investment, which you are trying as much as possible to attract. And then we decided on the need to review the case. And when the case was eventually reviewed by the Office of the Attorney General, the conclusion was never that of question or stopping the criminal prosecution, but the directives to the agency concerned was clearly to, to strengthen the investigation as far as certain key elements of the offense that was charged before the court was concerned.
Recently, there have been high ovation of allegations against the federal government, accusations that most of the charges are being orchestrated and being targeted and also being labeled as fake charges. And one of it was also re-echoed by the trial of the Senate president, in which they, even up to the point of the Supreme Court, they couldn't find any criminal evidence against him, and he had to be set free from the point of the law. When you look at this, other people too in that line also feel that the federal government is deliberately using the long arm of the law to witch hunt them. So is the federal government on a witch hunt spree, or is it still within the ambit of the law? Is it still operating within the ambit of the law?
Well, some of these cases you are making reference to as fake charges. One thing I want to place on record are mostly cases or charges that predate the present administration. They were cases or charges that were filed and indeed inherited by this administration that were indeed there even before 2015. In most of these cases, perhaps inclusive of the cases over which you said are not expeditious in being considered and determined. There were cases that have been there for over a period of 7 years or above, which by implication predates this government. So if you are now talking of fake charges within the ambit and spirit of the cases that are inherited, I want to place it on record that one, these cases are not cases that were initiated by this government. And indeed, they were there and being prosecuted. That is one. And then if you are now further analyzing, you are exclusive about the case of Saraki in that respect. If you are particular about that case, for example, the trial court, the trial tribunal, now originally and initially quashed and set aside all the charges. But when the case was appealed to the Court of Appeal, the Court of Appeal now affirmed and confirmed that the trial tribunal was indeed wrong in its conclusion that he had no case to answer, with particular reference to about 4 of the charges that were in. So the idea of fakeness within the context of the comparative analysis of the position of the trial tribunal and the Court of Appeal then does not arise, because if you look at it from the point of being pegged, and if you are contending that your position that it is pegged was sustained by the trial tribunal, the Court of Appeal look at it from different perspectives, that indeed there exists a charge to answer.
Before we wind down this conversation now, 2019 is around the corner. Our mind goes to the Electoral Act. Do you think that document is credible enough, is tenable enough to guide the electoral process towards a free and fair election?
By international assessment of the situations on the ground, attested to the fact that we are recording greater successes, not only in terms of fairness of the election, but in terms of its conduct by way of ensuring that there are minimal incidences of violations as it relates to the loss of lives and properties.
The Attorney General of the Federation and the Honorable Minister of Justice, Barrister Abubakar Malami, thank you so much for making our time to be part of this episode of Question Time. Thank you very much indeed.
Thank you.
Wish you the very best of luck.
Thank you.